Welcome to the session on Employee Compensation Act 1923. Earlier, it was called as Workmen Compensation Act, which by familiar everybody knows about it. But recently, the workman has been replaced by the word employee, and now it is called Employee Compensation Act 1923. Of course, this is one of the oldest, you can see 1923 itself, this is one of the oldest legislation we have in the area of social security. It is an act to provide payment of certain benefits in case of employment injury for a person by an accident. So hence, how far the injured person gets the benefit and how it should be paid and what is the liabilities of the employer in this case has been narrated into this act. So hence, this is an important piece of legislation. Here the definition of employee includes a body of persons, whether incorporated or not, and even an individual also. A legal representative deceased employer, he is also an employer. An individual also can be an employer, because if I hire people to get the work done through them, and if any injury happens, then I am responsible because I happen to be the employer. So this has got a very wide coverage. Then obviously, not only individual, then obviously any business activity automatically gets covered in this. Any type of activity, any type of relationship, wherever people are employed for wages, salaries or any considerations, definitely he becomes an employer and he is eligible for this. It means that all the establishment, even individuals who hire persons, are covered. Employee means any person. Only exception is that other than a person who is employed on casual basis is not covered. Otherwise, everybody is covered irrespective of his level. And includes a person recruited to work for a place abroad, he is also get covered. It means that I recruit a person, I send him abroad, and still he gets covered under the Act. It's a wide coverage. It means that all employees are covered. There is no categorization. Everybody is covered under this Act. Here, wages. Here is also very, we have to see very casual, very importantly, we have to observe this. Wages means any privilege or benefit is capable of being estimated in terms of money other than travelling allowance. So it means that it is all inclusive except travelling allowance. It means that it is the total gross salary excepting travelling allowance is gross salary. Here the wages means gross salary is meant to be taken into account for the payment of temporary disablement compensation only. Of course, when I deal with the topic of temporary disablement, I will explain in detail what is that. But for this purpose, the gross salary has to be taken. But for the purpose of compensation towards partial disability or total disability or in case of death, the salary to be taken into account is limited to 8,000 per month. So you look at the entire thing. For payment of temporary disablement compensation, you have to take the gross salary into account. For the payment of disablement compensation, it can be partial, it can be permanent or even fatal, then 8,000 rupees is the limit. So this you have to bear it in mind very clearly when we discuss the next chapters. Here the partial disablement means where the disablement is for a temporary nature, that is disablement or reduced earning capacity of a workman, and where the disablement of permanent nature, such that reduces earning capacity to every employment is capable of undertaking at that time, and injury specified in Schedule 2 and Part 1 shall be deemed to be a result of permanent partial disablement. So here partial disablement is a temporary disablement in nature, whereas permanent partial disablement is as per the injury mentioned in the schedule. In the schedule they have mentioned. What are the permanent partial disablement have been mentioned in the schedule? That amounts to permanent partial disablement. Then total disablement. It means that there is a total disablement where then he cannot be totally incapacitated person from all work which he was doing capable of performing at the time of accident resulting in such disablement. So here in case of this total disablement, here should be deemed to result from injury is specified in part 1 of the schedule 1 or from any combination of injuries in part 2 of the aggregate percentage of loss in capacity. So if his earning capacity is 100% or more, then it amounts to total disablement. Dependent means the widower, parent, other than widowed mother, etc. Probably if wholly dependent on earning capacity working at the time of his death. Total or permanent disability. Here, if the injury falls under the schedule, then he is entitled to compensation as per the percentage mentioned in the schedule. Loss of earning capacity is essentially ingredient, and loss in earning capacity must result in reduction in his earnings which otherwise he would have earned. Here what happens is that the injuries have been listed in the schedule and the equivalent percentage also has been mentioned in the schedule. Like for instance now, loss of one eye is mentioned in the schedule. The percentage of disablement is also mentioned in the schedule. Loss of both eyes, the percentage of disablement has been mentioned in the schedule and the compensation also to be specified as per that. Loss of one hand, percentage is mentioned in the schedule. Loss of two legs, it is mentioned. Like that, in the schedule, if you go through the schedule, it lists down all the possible injuries and the extent of loss of earning capacity. Then, based on the percentage of capacity, ratings are given. On that rate, we need to calculate the compensation, what is available, what is payable, it has to be paid. I will give some examples, then you will understand better. Here, in fact, in one of the Calcutta High Court, this case came. I will just read the operation portion of the judgment, then I will discuss with you. The definition itself shows partial disablement of a permanent nature must be such as it reduces the earning capacity of a workman in every employment he was capable of undertaking. If it is not a scheduled injury and therefore the earning capacity will have to be proved as a fact, no compensation can be granted for any physical ability unless there is loss in capacity. It is only a question of scheduled injury. It means such loss is presumed. It means that if the injury is occurred and it is mentioned in the schedule, the percentage, then the compensation shall be payable as per the percentage mentioned in the schedule. So no compensation granted on physical disability. That's not because unless you are able to prove that loss in earning capacity is only in case of scheduled injury, this loss is presumed. So here the worker can rely on, in the case of scheduled injuries, he should be confined himself to the compensation payable under this as per the schedule and percentage of disability as mentioned in the Act. That's all he can do, because beyond that he cannot. Say for instance now he loses one leg. The disability percentage is mentioned there. Then he is entitled only for that purpose and he cannot say that I am totally disabled, I am entitled for other things. That is not allowable. So his compensation is limited to the percentage of disability as mentioned in the schedule of the Act. Here also another case is in the AP High Court also the same principle has come. But if the workman is incapable to do all the work he is capable of performing at the time, it is a case of total disablement. It may be the view that the injury may be capable enough to render some other sort of work, but still capacity to do the work which is capable for early direct action is a case of total disablement. When total disablement is reassessed, this is how the worker was carrying. If the worker is disabled to perform the work he was engaged to perform, it amounts to total disablement. The fact that he can do some other work elsewhere is no ground to say that he is not totally disabled. In Karnataka High Court, in the case of Hanumanta Gowda versus Devaraju, it has been held like that. So, the thing is that his capacity to do other work is totally of no consequence. Whatever the disablement is, he is there, and then it is percentage is calculated as per the schedule and compensation is paid, and that's the end of it. Here the definition of wages does not actually purport the limit of meaning of the word wages. It includes ordinarily may be included in concept of wages, but leaves the meaning at large. Hence the claim for bonus is a matter of right of a workman, and definitely he can claim the bonus. So it means that he is entitled to payment of bonus as a matter of right. Hence, the wages as definition includes privilege benefit is capable of estimating in terms of the amount of overtime can be estimated in money. So amount of overtime is within this concept of wages. So this is another interpretation of wages made by Allahabad High Court. Here a person can be excluded from definition as one who is employed with casual nature alone. Otherwise, he cannot be. In both qualifications must be satisfied not to exclude a person from the category of workman under this Act. It is very clear. It means that those who are employed is of a casual nature, and also one who is employed otherwise than for the purpose of employed trade and business. Two things are there. If a person is employed otherwise than for the purpose of employed trade and business, then he is not a workman. Or a person is engaged in casual nature is not a workman. So both things must go together to say that in the definition of employee is excluded. So this is very important to note that. So important thing is that even the case of Kerala High Court also has reiterated the same thing, saying that those who are employment of casual nature, they are excluded from the definition of worker. Employment casual nature, if there is such regularity, periodicity of employment to indicate there is such a degree of mutuality, is there an obligation express and with the permanent for the purpose of trade or business, it has to be looked into. Supposing it cannot be casual nature because I use him every day, I engage him almost every day. I call him as casual, then you can't escape the responsibility that the nature of work is of casual nature. So we have to look into all these things. Then personal injury can be classified as two types of injuries. One what we call visible injuries and another called invisible injuries. Visible injuries, of course, what we see actually, the physical injuries. The invisible injuries are the occupational diseases. A person may be working in a dangerous operation in a particular factory. Over a period of time, on account of that, he catches some diseases, and of course he leaves the company and joins another company. And he comes to know of his disease after a few years working, although he is working in some other company. And if the medical officer comes to conclusion that this disease has occurred during the employment of his previous employment for having worked in such a thing, it amounts to employment injury, and the first employer is liable for payment of compensation to this person. I hope I have told you very clearly. If a person works in an establishment over a period of time and due to environmental circumstances he catches some disease which is not known to him now, and after some time he leaves and joins some other company, and then after that the disease is diagnosed, and then it results, it is diagnosed in such a manner that the disease has arisen on account of the employer, on account of the disease, on account of the working conditions in the first factory. Then if he makes a claim on that, and if he proves that, then it becomes an employment injury, and the first employer is liable to pay the compensation under this Act. This is what is called invisible injuries. This has happened in a number of times, in a number of cases that have happened. Here the employer's liability in place of compensation. Here the compensation is that personal injury caused by accident or in course of employment, payment of compensation shall be liable to be paid. The employer has to pay that. When he did not pay the compensation, on account of the injury, if the total partial result do not exceed 3 days, if the injury on account of this and he is able to remain absent for a period of less than 3 days, the principal the employer need not pay the compensation. In case it exceeds 3 days, then he has to pay the temporary disablement compensation he has to pay. Then if the workman have been at the time of accident, if he is under the influence of drugs or alcohol, then the employer need not pay the compensation. And in case there is willful disobedience of workman in to an order expressly given or a rule made by the employer in not following safety precautions or safety equipments, then in such case also employer need not pay the compensation. Then willful removal or disregard for any safety device. Many times we see that people purposely remove the safety devices installed in the machine and remove that for obvious reasons. Then in such case, if it is proved, then the employer need not pay the compensation. Otherwise, the compensation has to be paid. Then in case of occupational disease, employed for a continuous period not less than 6 months may contract a disease in part A of the Schedule 2, I told you already, or under any employer the same kind of employment contract any disease, again this is almost occupational disease, or if the workman whilst in service of one or more employers as specified in part B of Schedule 2, again all these things are called as occupational diseases. Then if a workman contracts such occupational particular employment and all such employment is more than one employer, then all such employers shall be liable to pay compensation in proportion as the commissioner may decide. See, for instance, he works in a factory. Let us say he works in a factory with manufacturing of, let us say, acid-based equipment. He works for some 6 months. Then he joins another company of similar nature where acid is used as a basic equipment. He works there for, let us say, 1 year. And then he leaves the company, he joins another employer of the same manufacturing, like acid-based systems. Then what happens? On account of the continuous inhale of the acid fumes in the first employment and the second employment and in the third employment, and ultimately diagnosed having a occupational disease arising out of this, then the compensation shall be equally, proportionately be paid by all the employers as the commissioner may feel fit. This is how the compensation is taken care of. If it is not proved, then whichever the employer with whom he has contracted disease, then he is eligible and he is liable for payment of compensation in case of occupational diseases. Here, when he is covered under this act, the person he cannot go to any other civil court and claim compensation other than this. He cannot do it. It means that a dual claim is not admitted. If he prefers to claim under this act, yes, he is. But he cannot go to civil court and claim the compensation through other source in exposing statutes, liabilities, etc. It's not permissible. It is not possible. Hence, this act is very wide coverage as per the injury caused out of and arising out of accidents in the course of employment, and the exceptions are very, very restrictive. The responsibility of the employer to prove that the exceptions are beyond doubt to overcome the liability, etc. Otherwise, in most of the cases, the benefit is given to the employee since the legislation is of one of social security. There are a number of cases which dealt with the question of employment injury. I will give some few illustration cases to say that how the injuries can be termed as employment injuries. Now, for instance, in one case it so happened, a pointsman in the railway station was on duty. He was manning the railway gate. When he was manning the railway gate, some persons came and attacked and killed him. Then the question of the compensation came, whether it is an employment injury. Actually, the commissioner held it is an employment injury because killing, he died, it is an accident. But it arose out of, in the course of employment, because he was in employment, because he was standing near the gate, he was waiting for the train to pass, he was manning the gate, then it is an employment injury. Then here, in an irrigation department, one Kalasi was employed to guard the regular canal, and then when he was doing it, he was murdered. Then what happened was that, again, it was found to be the employment injury because it happened in the course of employment. While going to work, a person was attacked with a knife on her left hand by a co-worker and she was injured. The worker was found near the muster to get herself assigned the place of work. The contention of the injury was in no way connected with her employment assault due to some personal enmity, but it was held that the accident arose in the course of during the course of employment. It does not. What it matters, the place of joint action occurred approximately the same and needed our presence at the time irrelevant. Hence, in this case, they said it is an employment injury. Look at this. She was going to her home. Somebody attacks and then he causes injury on her left. Somebody stabs her. But the incident happened in the course of employment because of the proximity. Hence, it is held it is an employment injury. Then here, a workman suffered chest pain and died of heart attack. There was evidence connection between the death and the employment, and the death arose on account of and in the course of employment, in the pace of it happened. Because here, the important thing is that there should be a connectivity between the death and the employment. This is very, very important. For instance, in one EPRCT case, one conductor developed chest pain while on duty and he died of cardiac infarction. Then it was diagnosed that death was due to his strain of the disease because he was working since morning. Being a conductor, he is always under pressure by the public and he was under tension, and on account of this, he got the contract's infraction and then cardiac infarction and he died after that. Hence, it is an employment injury. Then a workman met with an accident while on duty on his way to duty. Here, the doctrine of notional extension theory of employees was applicable and accident compensation has to be paid because the notional extension theory, it holds good in the case. Then here also, notional extension theory happened because the workman was returning while home in a lorry provided by the employer. In fact, the transport provided by the employer. So he was traveling on that, the trolley toppled and then he died out of that, and it is an employment injury, and the management had to pay the compensation in case of Mysore Mirrors in 1995. Here also notional action theory comes in the picture. A workman was reaching his factory, necessarily cross a river. On that day when he was crossing a river, suddenly he was washed away and died. Then this is also termed as employment injury and the compensation had to be paid. In another case, the workman was beaten by the employer and his men for refusal of work for more than 16 hours. Obviously, it is an employment injury. Then again, to the notional extension theory in this case, he was going to house while he was constructing, met with an accident in his death. Here what happened was that the slight different distinction, because every day he was taking a particular road, but he was constructing a house in a different direction. When he was going back, he took the other direction in the sense he did not take the normal road, but he went the other way to the progress day of the house. He is constructing a different side, and then he was going back. At that time, he met with an accident. In the case of Steel Authority versus Kashimbala Mohanty in 1995, it held that it is not an employment because the workman took a different road to reach his house. Different road. This is not a normal road. Hence, they said that it does not amount to notional extension theory and compensation will not be payable. In the case of railway, very peculiar incidents happened. In the railway platform, a drum was kept and it was filled with water. And one of the workmen of railways, he was going in the platform, walking in the platform and drank that water and he developed infections and then died. Then it was held that it is an employment injury because it happened in the course of employment because he drank the water which is kept on in the drum which is not safe. So that's how it is concluded. Then similarly in one case, the captain of a barge, while inspecting the barge, he slipped into the river and fell down, and the defense was that the captain was fully drunk. Held that the accident, but they were not able to prove that he was in a state of drunkenness. Hence it was proved that the accident arose in the course of employment and compensation had to be given. Then if an employee dies out of heart attack, then it is amount to accident and employer shall pay compensation. Actually, particularly in this case, people died out of heart attack. There are any number of contradictory views in the judiciary. Some courts have taken a very liberal view in the sense that if a person dies out of heart attack while on duty, it is an employment injury, he is entitled to compensation. The other view is that supposing he developed chest pain because he was a heart patient right from beginning and he was in continuous treatment and the heart attack arose on account of the continuous illness but not on account of the factory, then it has been all held that it is not an employment injury. So there are very, very diversified decisions in this matter and there is no very concrete parameters to say that whether the death on account of heart disease, heart attack, will amount to employment injury has been a matter of debate in number of cases. In fact, heart attack while on duty will be considered as accident in one of the cases in 2005 in Allahabad High Court. Then, in case of Mumbai Corporation, they said death due to heart attack cannot by itself be presumed that it is an accident occurred. Then, death due to cardiac arrest, even at workplaces, in the course of employment will not amount to accident in the absence of evidence that death was due to stress or strain. You see, you have to establish that the death was due to stress and strain, then only it amounts to fatal amount to employment injury, otherwise no. So this is an important thing. Then the concept of notional extension theory while granting compensation is applicable where there has been reputed evidence to show that the death has occurred due to stress and cardiac arrest on his way while returning home on his duty. See, this is also in the notional extension theory we say that when he is going back to house, if he dies, or if he meets with an accident, he is going to die. But in this case, what happened? He was going home by walking and he collapsed due to heart attack. The question came whether it is an employment injury or not. Though the court said that there is no limited evidence to prove that he died not due to the stress and strain because of something else. No limited evidence given, so it was not possible to conclude. No compensation claimed when a cleaner makes an accident driving the tractor because the cleaner is not supposed to drive the vehicle. When the cleaner is not supposed to drive the vehicle, the employer is not responsible for it and no compensation to be paid out of this. Then these are some few cases have occurred in various, there are a few illustrative cases. This one is not exhaustive. There are any number of cases on account of this. It all depends on the facts and circumstances of the case. But it's a social legislation. The interpretations are quite liberal in the sense the benefit doubt will be given to the family in case of any kind of employment injury. Hence, under the circumstances, they say care. So it has to be viewed from case to case basis. It depends on facts and circumstances. Now the question is amount of compensation. Supposing when the death occurs, what is the amount of compensation payable to him? Law says, the table says, amount equal to 50% of the wages of the deceased workman multiplied by the relevant factor or an amount of 1,20,000 rupees, whichever is more. This is what it says. Then where permanent or total disability take place, an amount equal to 60% of the wages of the deceased workman multiplied by the relevant factor, an amount of 1,40,000, whichever is more. Then, when the permanent total partial disablement takes place, if the injury is specified in the schedule, then as per the specified schedule, loss of earning capacity to be taken into account. Then if the injury is other than the above, the loss in earning capacity should be decided by the medical practitioner. Now let me explain this. See, a lot of injuries have been listed in the schedule. Standard injuries, like for instance, loss of one eye, loss of one ear, loss of one finger, loss of two fingers, loss of one leg, loss of, all things are listed out and the percentage of disabled, percentage of incapacity has been assessed and mentioned in the schedule itself. But there may be some injury other than the scheduled injury, what is mentioned. Then what is the loss in capacity? Then in such case, the medical officer has to assess the extent of lossing capacity in my examination, and then he has to decide, and he decides what should the percentage of lossing capacity that should be taken into account. Now here, what is monthly wages? Here the explanation is given, because in the first text is a percentage of the monthly wages. Here the monthly wages, as I said in the beginning itself, monthly wage for a workman exceeds to be 8,000 per month. His monthly wages for the purpose of calculation and compensation shall be 8,000 rupees only, as I told you already. Now please look at this slide. I will just explain to you. If you look at the slide, you can see this. The example I have worked out, where the death results from an injury. His age is 46 years. Then 50% of 8,000. Because we have to pay 50% of the monthly wages, that is 8,000 rupees. So 50% of 8,000 rupees is 4,000 rupees. So 4,000 rupees multiplied by the relevant factor. The relevant factor in case of death for 46-year-old person has been fixed at 166.29. This is the point. The factorization point. The factorization point depends on the age of the employee. The younger the age, the points are more. The older the age, points are less. That's how it is calculated. In this 46-year-old person, the relevant factor is 166.29. Now, if you multiply 4,000 into 166.29, the amount what you get is 6,65,160 rupees. So 6.65 is the compensation payable to the deceased family. This is how the compensation is calculated. Where it is a permanent total disablement from the injury. Let us take the same example of 46-year-old person. Then we have to pay 60% of 8,000 rupees, which is 4,800 rupees. The relevant factor is the same thing for this. The relevant factor for death and permanent disablement are same, because ultimately both are same. Here the person dies, here he lives, but he is total disablement. So the points are same, that 166.29. Then multiply 4,800, then it comes to 7,98,000 rupees. So this is the amount of compensation what he gets, and this is how the compensation is calculated based on this. Then in addition to this, there is also stipulated way called payment of half monthly payments. Half monthly payment, this is called temporary disablement. Whether it is total or partial, till the decade is decided, he has to get the temporary disablement benefit. For calculation of half monthly payment, the monthly wages shall be gross amount. It is not 8,000 rupees, it's the gross amount. It's a broad-based one gross amount. It is inclusive of gross salary. So here what happens is that if the disablement is more than 3 days, then injured employee shall be entitled for half monthly payments. Then payment should be done like this. 25% of the monthly salary is payable. Then the payment has to be done every 16th day. It means that he has to get 2 installments equal to 25% of the monthly salary in a month. On the 16th day he should get. In other words, he gets 50%, and if you take total, he gets 50% of his monthly salary in a month approximately. That's how it is. You look at the duration. The duration may go up to even for a period of 5 years. Here, and any payment made by the employer to medical treatment shall not be deemed to be compensation under this provision. See, for instance, for medical treatment, employer may spend money for treatment, etc. But that shall not be treated as compensation, and the employer cannot deduct any amount out of this. It means that the cost of treatment shall be borne by the employer. Now, here, how long? Actually, this amendment has taken place in 2010. It says that under section 2A, it said it is obligatory on the part of the employer to meet all the expenses in connection with the employment injury, in connection with the treatment of the injury. The employer has to meet all the expenses, and it shall not be recovered or adjusted in any manner in the compensation payable. It means the employer has to meet the complete expenditure of the treatment. Then arising out of this and during course of employment, there are 2 things. Arising out of means while engaging in work. In the course of employment, is that coming and going, etc., various there. Such an injury results in disablement of the worker. This is the definition of arising out of and in the course of employment. Then loss in earning capacity and compensation, which you already talked about. Loss in earning capacity in terms of percentage of injuries mentioned in schedule to be taken. It is not mentioned in the schedule. Non-scheduled injuries, it has to be assessed by the medical practitioner. In both cases, calculations of compensation and percentage of earning capacity, medical factory, same, both are same. So it has to be done like that. Then the loss in earning power should not be confined only to the present capacity. The worker is currently employed, earn the same salary. It cannot be said that if future employees compelled to seek employment. You see, we cannot say that okay, I have paid the disablement compensation, so he can take up any other employment elsewhere at a reduced compensation, so I should not be paid the compensation. That will not hold good. Whether it is very fact that there is only limited present capacity. That okay, today I am getting the incapacity, the compensation to the extent of incapacity, I am getting it. But still I may do the work, but nobody can adjust and say that you are doing the work, but I am not going to pay the compensation. That argument will never hold good as per the decisions of the Madras High Court. The method of calculation of wages is very clear. You have to take the average salary during preceding 12 months. In case of salary is paid less than 1 month, then the average worker to be paid same work during preceding 12 months. In case of daily workers, the average daily workers multiplied by 30 days to be taken into account. The question is, how long the half monthly payment? I told you already it is payable for 6 years, but there is a provision. The employer can make an application to the commissioner for review. The review may continue, the review order, it may be continue, decrease, increase or end, or to convert into lump sum payment. It can happen. Depending on particular case, the commissioner may decide whether to continue the payment or increase the duration or decrease the duration or to end it or convert it to lump sum payment. This decision is with the compensation commissioner. For this purpose, the commissioner shall hold the proceedings in presence of both the parties, and parties can adduce evidences including medical evidences or in relevant factors, and the order is abided by the order by the commissioner. So actually the proceedings before the commissioner is almost a judicial one. So hence the order of the commissioner is binding on all the parties concerned. So here there is one particular thing here. It mandates that no compensation shall be paid in respect of any resultant death, and the employer cannot make any direct payment to the family. He has to make the payment only through the commissioner, then only it is compensation. If he makes any money directly paid, then it is not a compensation. So any compensation has to be paid to the employee, family of the employee should be through the commissioner only. It means that the employer has to submit the report of the accident, then he has to deposit the amount of compensation payable to him by check to the commissioner. The commissioner will come in the meeting, he will decide to whom the money should be paid, and commissioner will pay the money to the legal heirs of the deceased under an agreement, under a settlement. It has to be paid. Otherwise, it is not a compensation under the Workers' Compensation Act. So this is a very, very important aspect. Just suddenly we can't take sympathetic view and then pay 6 lakhs, 7 lakhs and be done with it. It's not correct. It has to go through the commissioner in a formalized manner, and it has to go through all the formalities, then only it's called as compensation. Otherwise it will not be deemed as compensation. So the statute requires anything to be done in a particular manner, it has to be done in the same manner. The statute prohibits an employer from making any payment to disabled to pay directly. So it is not accepted. It is very clearly said in Gujarat High Court decision in the case of Sambin versus Patel Industries in 1994. This is one of the cases what I told you just now. Here the another protection is given. Compensation cannot be assigned, attached or charged by any civil code and set off against any claim. This is totally barred. Nothing is possible. Then reports of fatal accidents and serious bodily injury. Here in this case, an intimation, notice and intimation has to be sent to the commissioner within 7 days of the occurrence of the death or serious bodily injury, and it has to be sent to the commissioner, and other formalities to be taken care of immediately. Then here, this is a very, very important provision under section 12 of the Act. The liability of principal employer in case of contract employees through contractors. Here, the section 12 clearly mandates the principal employer shall be responsible for any payment of compensation. There is no doubt about it. So law says very clear, saying that if any contract workers meet with any kind of employment injury or even fatal accident due to employment injury, the principal employer is able to pay, but not the contractor. It is straightway shifted on him, and in case this has been endorsed by Vittala Rao versus Venu in the case of 1973 in Kerala High Court. So it is very clear that the principal employer is responsible in respect of contract workers. In case of the similar thing has been upheld also in case of Gujarat High Court, where in case of Century Minerals Chemicals such Valley Garden Lakshmi Bai case, the same thing has been held, saying that the principal employer is responsible. Similarly, in the case of Payaro Education Society versus Narayani in 1996, Kerala High Court has said the same view, repeated the same view, that the contractor, principal employer is responsible. In the case of Orissa State Warehouse Corporation versus Srimati Geeta Rani, Orissa High Court also reiterated the same thing, and principal employer is liable to pay the compensation. Then here also in the case of Sujay Rao Unkar Jadhav versus Gujendra Singh in Bombay High Court has repeatedly said the same thing, saying that the principal. In the case of Sujay Rao Unkar Jadhav versus Gojendra Singh, this happened like this. The principal took a contention saying that there is an agreement between the contractor and the principal employer, and the contractor has indemnified the principal employer against payment of any compensation payable under the law, etc., etc., etc. And he took the same plea before the Bombay High Court, but the High Court rejected the plea, saying that the section 12(1) is very, very clear. Come what may, whatever the consequences are, the principal employee is liable to pay and you will have to pay. So this is the decision given him. This is about few cases of what I mentioned you on account of all these things. Then all proceedings before the commission, including appeal matters, shall be judicial matters. It means that the commissioner shall have the same powers as vested under the Civil Procedure Code to hold proceedings, depositions, examinations, cross-examination, and review of documents, call of document, call issue summons, etc. Everything he has got, it is absolutely a judicial proceedings before the commissioner. Then registration of agreements. I told you already that any compensation shall be through agreement only. It need not be the compensation payable on account of fatal injury or even any kind of permanent partial disability injuries or any compensation payable to an injured person. It has to be through the agreement made in front of the commissioner only. Otherwise, this will not be treated as compensation under the Act. So registration agreement is very, very much required and it is mandated. And if the agreement is not sent and registered, the employer shall be liable to pay full amount of compensation which he is liable to pay under compensation. Look at this. It stipulates that if you fail in this, the employer has to pay once again the compensation under this. So you must always keep it, remember, saying that all the compensation should be routed to the commissioner, paid in his presence through an agreement made in his presence. And here the Employee Compensation Act Schedule 1, it gives a list of injuries deemed to result in permanent total disablement. You have to refer the act, the schedule in the act that gives a broader picture of it. It shows the description of injury and the percentage of loss in capacity. Then part 2 of the schedule shows the list of injuries deemed to result in permanent partial disablement, and it also shows the extent of earning capacity and the percentage of loss in earning capacity. Schedule 2 gives a list of persons are included in the definition of employee. Now, of course, on account of this definition, it's quite exhaustive, everyone is included. Then Schedule 3 gives list of occupational diseases. Here, the earning capacity, loss in earning capacity is not mentioned because it differs from case to case, person to person. Hence, this has to be decided by the medical officer and he has to make an assessment of loss in earning capacity. Then Chapter 4 gives the factors to work out the lump sum compensation equal amount in case of permanent disablement or even death. I gave the example of factorization. Schedule 4, this is narrated and gives. Actually, even today this act holds good, and this act is applicable for the people who are not covered under ESI. Because ESI Act also says that if they are covered under ESI, they cannot make any claim under this act. So it's very clear this applies only for the people who are out of the coverage of ESI or where ESI is not applicable. Only for those people is the beneficial and it is proceeding well, and it's a very old act, but it's a very, very socially, it's a very beneficial act. Thank you.